Hey everyone, this is Nick Wooten again with Consumer Trial Lawyer Academy, and we're here to talk about another topic and sort of bring to a wrap our topics along the portions and pieces of a trial. And what the plan is from here is that we'll go back in and do some more specific videos on some more particularized issues and try to give you more practical knowledge and insight that's tailored to particular portions of trials based on 26 years of doing this, and try to go back and teach particular issues with a little more finer detail on some topics. So if you're interested in certain areas or topics, please feel free to drop a comment into any of the videos about things you'd like to talk about, things you'd like for us to talk about in more detail. It seems that the viewers really like our videos about taking depositions, so probably be posting some videos where we actually take a video deposition from some of our cases and kind of go through the methodology so you can see it in action of what I do and how I do it, so that we get to the right result and make best use of our time with depositions. So today's topic again is closing statements and arguing damages. And closings are, in the movies, are always super dramatic, and they're always like, the point where the hero rides away with the wind, so to speak. And closing arguments can be dramatic, and they can be emotional and impactful and compelling. And, it's your job to use that point of the case to bring home the importance of the jury's power to impact the wrongdoing that you've presented to them. And so, it can be one of those things where you can overthink. But really, the way that I have had my best success with closing arguments really is this. We always tend to focus on, first of all, we use David Ball's method for opening statements. And then we go back in closings and we tend to go back through and talk about what we promised that we would show and where that evidence is that we promised. And we also talk about our damages. And we also talk about the jury verdict form or the charge, depending on what state or jurisdiction that you might be in. A lot of states or jurisdictions have a simple yes/no question. Did the plaintiff win? Yes or no? Do you find in favor of the plaintiff? Yes or no? And then some jurisdictions have jury charges that are basically a series of questions, or in essence jury interrogatories that have to be answered, and you have to set those up so that they follow through the steps of the case. And Texas is one of those that you answer a jury charge rather than answering, do you find in favor of the plaintiff or no? There's strengths and weaknesses of both those types of closing or verdict forms as to how they play into your verdict and your closing argument. But the one thing that we always do, and of course we learn this obviously by studying ourselves and reading and applying the things that we learn from people like Ball and Keenan and those types of folks, is that during that closing argument, one thing we're going to do is go through that verdict form, and we're going to show that jury, on the whiteboard, so to speak, how to fill in that jury verdict form so that we get the results that we're looking for at the end of the case. So there's nothing necessarily rote or magical about the way that we go through that closing pace. I look at it as an opportunity to speak again directly to the jury, to talk to them about the justice that they can provide for my client, and then to educate them on, the right way to do it. Because if we don't do that, you're going to end up with all kinds of glitchy, weird outcomes. Because trust me when I say it is wrong to assume that the jury will understand the correct way to fill out the verdict form. So you definitely need to show them how you want it done to get the outcome that you're expecting. And I can tell you from doing it both ways that they will appreciate the fact that you walk through it with them, especially if you can do it. You have to do it in a non-condescending way. And if you've done those two things, at the end, you should get the type of verdict that you are expecting. At least you should get the right answers. They may not agree with you on damages. They may think your case is worth more, worth less, but at least you should get the right answers in the right spots so that you've got a verdict that you can, defend on appeal. And that takes us to the idea of how do we argue damages. Jurisdiction is sometimes judge specific as to what they will or will not let you argue, and you've got to go ahead and do your research so that you know what's up. It's very funny. Lately, the defense argument that I've faced the most is that we don't get to lay out some type of formula for a jury to consider the impact of damages on the plaintiff. We just went through that in a case. We got through the third day of trial before it settled. But we had tremendous resistance, voluminous writing, opposed to the idea that we could lay out a formula to explain things like how many hours our clients had suffered because of the misconduct they had faced. And, honestly, I think the reason that we got that is because it's powerful and effective. On the other hand, the defendants will always argue, post-trial and even pre-trial, they argue against your damages on the grounds that there's no formula for calculating damages. And so when you try to argue one, then they don't want you to argue that because it explains to a jury just how, just how much harm your client actually has suffered. And it shows them two things. It shows them the justice of the dollars that you're asking for, and it shows them the injustice of the dollars that the defendant is suggesting as a proposed verdict, to the extent they're arguing that your client is entitled to a verdict. The good thing about most consumer cases is they, to the bloody end, argue that your client shouldn't recover anything. And that always tends to piss jurors off, especially after you've embarrassed them pretty badly. So, let's assume that you're in a jurisdiction where, you can argue sort of a formula for how you calculate damages. One of my favorite ways to do that is to sort of break it down in a way that, it helps a jury to visualize the length of time that this has gone on. And so typically what I do is, I take the total amount of time, the 24 hours a day, times 7 days a week, times however long that's gone on, to get the total amount of time that my client has been impacted by the defendant's conduct. And then from there, we break that down into, a total number of hours, and then we convert that into, 40-hour work weeks, and then we take that and we multiply it to get the total number of work years that a person would have to work to get to the same amount of time. And a lot of times, for instance, one of the cases we tried to verdict, the Sacamino case, when we ran that math problem out, the number of hours involved in that almost 5-year experience, if you were going to work that as a job, it would have taken about 20 years to work that many hours. And I think that was very impactful to the jury to understand the magnitude of how long this had gone on. And so that, I think, was helpful in getting the types of verdicts that we want and expect for these types of cases based on the harm that our clients have experienced. But when that's taken away from you, and you can't really break it down in that level of detail, the place that you're going to feel like you're stuck with, well, I'm just throwing a number out in the air. And that's, unfortunately, that's kind of what it's like. So you need to know, why you're asking for those numbers that you're asking for. And this is another place where the verdict form can come in handy. In some states, they break these damages down into past, present, future damages. So you've got a jury verdict form that's got multiple lines for damages that you need a number entered on. And, and then some states, it's just simply a dollar amount. What is the total compensatory damages? What is the total punitive damages? So you again have to adapt your closing to your jury charges and your jury verdict forms. But when you're able to lay out a number and talk about how that has gone on for a long period of time in the past, and you can break it down like we talked about, the number of hours, that's always a great way to help increase the magnitude of the severity and make it real for the jury. And then if you're dealing in cases where there's a permanent injury element and you have, the expectation and belief that that injury is going to continue forward indefinitely, then at that point, you have things like life expectancy charts and tables where you can say, in one of my PI cases, we got someone that's got a permanent back injury, never going to get over it, and they expect to live another 45 years. That's a lot of pain and suffering over a long time for that type of scenario. And, basically, those are the things you're looking for that can make the amount of harm that your client has suffered real to a jury to support the damages that you're asking for. And then, of course, probably the most important part of all that really is that you believe in what you're asking for as well. If you think in your mind that someone losing their home or being on the verge of losing their home for 4 or 5 years is really worth $250,000, then it's hard for you to look a jury in the face and tell them that they should award $2.5 million for that. And part of this stuff comes from our own lived experiences, right? And, from my own self growing up poor, growing up on the edge of the abyss financially, hearing we can't afford that, living we can't afford that, knowing that the tension and stress that is in your life when it might be too much to ask your parents to take you through the drive-thru at McDonald's. it's it's a little easier for me to get real with that than maybe someone who lived an upper middle class life or had lots of resources when they were young, because I've been there. I've been on the verge of homelessness. I know how real it is and how difficult it is. And I've been there even as a young lawyer, going through divorce and struggling to take care of my own family when I was younger, and having those fears of what happens if I can't do this or what happens if I can't do that. It's very easy for me to internalize and know just how traumatic that is. And so I think it's easy for me to communicate that to a jury and make it real. And so when I say a number, then you can believe that I know that that's what that case is worth in my mind, because, I know what those clients have been through, and I've been there in some ways myself. And so, if you don't have that, then you got to get it. And, if that means you go and you work in a soup kitchen feeding homeless people, or you are dealing with someone who is, on the edge like that, and you're having to walk through with them sort of their, trying to find services and help and assistance so that you see the difficulties they actually face. Or if you just, spend time with your clients who are going through these issues at these critical moments where it's difficult, you have to find a way to know that when you stand in front of that jury and you ask for whatever that number is, that that amount is just and right for your case. And if you can't do that, you need to find someone who can help you try the case, who can, because, at the end of the day, you owe it to your client to get them the best possible recovery. And if you don't believe in the value of their case, I can trust me when I tell you, the jury will sniff that out very quickly. The defense will sniff that out very quickly. The judge will sniff that out very quickly. And, it will reflect on the number that gets written down. And that's something that I think a lot of people miss. I think sometimes it's a defense mechanism. You don't want to think about how difficult it is for your client. You don't want to think about the magnitude of what you've stepped in to try to help resolve. Sometimes I think it comes from a lack of experience addressing this degree of economic harm. But whatever it is, you have to figure out for yourself how to live in it and know how real it is and how harmful it is before you try to stand up in front of a jury and talk to them about it. I'm not suggesting you go be homeless for a week or anything like that. I am suggesting that you make sure that you have fully invested in understanding just how destructive this is to your client, so that you can truthfully, forcefully stand up and ask for an amount that represents justice, given what your client has been through. And that's a huge part of, why you do what you do, in the closing arguments section of the case. And then, of course, when it comes to punitive damages, there are lots of ways to argue for punitive damages, but you're going to face all these crazy arguments about proportionality and ratios and all this other nonsense that has nothing to do with anything. So we'll create a separate video to talk about the punitive damages aspect, because this one's getting plenty long enough. But basically, there are a number of ways to address that also, and we'll address that in the next video. Thanks again for joining us at Consumer Trial Lawyer Academy. Hope this has been helpful to you. If it has, please like and subscribe. And again, invite you to leave any comments about areas you'd like for us to talk about. and be happy to try to address any topics we think we can provide any insight on. Again, this is Nick Wooten. Appreciate your viewership and look forward to seeing you on another episode of Consumer Trial Lawyer Academy.